that is before the House, then the Commission can be able to have more powers in terms of sanctioning, more powers in terms of prosecution. And I do believe that also the Commission is not isolated in terms of work, and we can be able to work with the security apparatus so that they can support the Commission in terms of achieving its mandate of making sure that people who have done hate speech can be able to be dealt with. On the freedom of speech and hate speech is that as much as we have the freedom to speak whatever we can, I do believe that every Kenyan has the responsibility to look at or to see or to gauge at what he or she says, because largely what is coming out is that by a mere word in terms of what you say can be able to create disharmony, can be able to cost life. So I do believe that though we have the freedom of speech as a country, we need to be able to be moderate so that we can be able to take care of the repercussions, because you see, if you just speak the way you want to speak and you don't think of the repercussion, then ultimately that has a bearing into the lives of people. So I do believe that as a commissioner, I will be able to propagate the aspect of people speaking rightly. They can be able to gauge what they say, and in terms of hate speech, then we can be able to measure, even define clearly what are what is considered to be hate speech, so that if today I go out and say something and it is considered to be hate speech, then the rule is very clear in terms of prosecution and in terms of following the law. On the issue to do with conflict between the Somali and the Kamba, I am aware, Honorable Member, that this has been a thorn in the flesh in those counties. And it's unfortunate that we have lost those numbers of people. It is, I am seriously sad about it. And I do believe that I will be impartial, because at the end of the day, I will be able to represent all Kenyans, regardless of where they come from. So first thing, I think we need to understand the root causes of this conflict. What are the key issues? Is it politically motivated? Is it resource-based conflict? We need to understand, we need to map out the hotspots of this conflict so that we can be able to have a long-lasting solution. And if given an opportunity, regardless of where I come from, whether my relatives are the ones who are doing that or not, I'll be able to act impartially and find justice and fairness to those who have lost their property and life, because at this age and time, we don't need to lose those number of people. And you see, even I was even looking at in the social media, politicians who are puking hate in terms of between the two communities. And I think as a commission, that will be some of the first things that I will propose we act upon, because I saw a person who was talking ill of what happened in Garissa, and that has now spread over to even the road users. I saw yesterday a number of buses were attacked, and it's unfortunate because of a statement of an individual that it can cause that level of disharmony. And therefore, I do believe that every person should have the statement you say, you shall be able to measure to it, because a person says something and they get away with it, and that has a serious ramification across people who have been living peacefully. So, Honorable Member, I'll assure you that I will be very impartial. I will take the bull by its horn, regardless of the people who are doing this. Even if they are my closest relative, I'll be able to act upon on them. Thank you. On Honorable Maungu's question around NADCO report, where there's a proposal to abolish NCIC, I do believe that, as earlier indicated, that this institution is a very important institution, because I do believe that for us to have peaceful coexistence, for us to eliminate discrimination that has been long been within us and has been a thorn in the flesh of this country, then we need to have a vibrant institution that can be able to carry that agenda forward, and an institution that has the ability to be able to represent all Kenyans, and an institution that can be able to bite, as you said. And I do believe that if we can be able to give the Commission the ability to prosecute, the ability to sanction, and the ability to act on incitement, then we can be able to have a Commission that has that is very vibrant. So my point of view is that I think the institution is very relevant, and if given the necessary support by legislation, and even working on the mandate of the institution, if people implement the mandate of the institution the way it is, then we can be able to have the right institution. On the issues to do with the conflicts with counties and the county assembly, mentioning the County Public Service Board adversely, Honorable Chair, I do remember that during our reign as a County Public Service Board member, we were very compliant with the submissions to the County Public Service Board. The annual submissions that legally we are supposed to provide, we were very, very apt with it. I remember when we came in, the previous board was not submitting, but as a board, we made a conscious decision that as a County Public Service Board, we need to work with the County Assembly in terms of compliances. And the issues to do with also the transparency and the ch to do with the 70-30% rule, where the 30% should come out of the county in terms of the workforce. Honorable Chairman, in my reign, when we were doing the appointment or recruitment, we were given an opportunity to every Kenyan, because all the advertisements were done in the daily nations, so that any person of this country can be able to apply for those positions. Also, we were given the opportunity to the locals in terms of making sure that they were well informed. We were able to have all the notices with the requirement and the advert on the notices. So I know largely the counties are, the dominant communities are trying to force in terms of the public service, but as a board, we did even, I was talking about the equity plan, where we are trying to see other Kenyans in terms of making sure that we are able to give them opportunity. And the last recruitment, I remember we recruited nurses, and there were a number of non-Somali who are the dominant community then. We gave them an opportunity in terms of the technical, because largely the technical people were coming from outside the precincts of the county. So I do believe that from where I sit during our reign, as much as possible, we were trying to be fair. We were trying to be just in terms of trying to see even people living with disability. Moving it from 1.5 to 2.4, I think is not a mean achievement. So I do believe that as much as there's need to do more in terms of making sure that we're more cohesive and give even surpass the 30% rule, I do believe that we tried our best in terms of making sure that we had the face of Kenya in the public service. Thank you.
Okay, Honorable Martins.
Thank you, Chair.
Towards the end.
Thank you, Chair. The nominee has used very good words for me, but you need to convince us, because you know, Wajir is just one county. What you are aspiring to get into is a national office. Now, you have mentioned that you speak your mind, which is good. It's a good attribute in terms of leadership. You also said that you can stand your ground. And lastly, you said you can take a bull by his horns. And there you are dealing with the MCAs, with the executive. Now, at the national here, especially when we are talking to hate speech and all this, We have very shrewd politicians, including presidential candidates, MPs, senators, and we have VVIPs, wealthy people, well-connected. Now, those are different type of bulls. I don't know, where have you practiced taking horns when it comes to that kind of people? And how can we believe you that you are experienced enough that if they make unwarranted utterances in a public that has stirred emotions and commotions and conflict, that you will call them to your desk? Where have you practiced? And how can we believe you?
Okay, nominee, also my last question. Your thoughts about using the media in fostering national cohesion. Proceed.
Thank you, Honorable Martin, for that question. I think in terms of, I believe in terms of what I've said, in terms of my abilities to be very neutral, I do believe that. There are instances in my work where I have been able to stand on the ground and say, this is right. A point is when we were doing the recent employment where there was serious push from the executive in terms of giving an opportunity to people maybe aligned to a particular thinking or a particular ideology politically. And I do remember in a meeting stating my point very clearly and saying that we have declared vacancies for people, for everybody in this country. And as much as we respect your opinion in terms of maybe wanting to employ a particular individual, we are supposed to give opportunity to everybody. There were even instances when there was a push in terms of not publicizing even adverts. And I do remember with the help of our chair then, who had over 40 years experience in the public service, us standing on our ground and saying that we are able, we will be able to do our work, facilitate us so that people can be able to apply. And it had some implications from the executive. It had even budgetary implications on the County Public Service Board, which the reason why even the National Forum was formed is to try to see how to make the institution independent so that it can have financial autonomy to make some of the decisions. So I do believe as a commission having the mandate and also having the independence in terms of the constitution and even financial resources, I'll be able to stand on my ground to say whatever a particular person, he or she has done is illegal. And I know the pressure will be bigger than what I've experienced. But I do believe that the Constitution of Kenya and the legal frameworks of this country will be able to protect us and protect me as a commissioner, so long as I'm standing on the right line. So I do believe that with my courage, I'll be able also to be supported by the necessary legislation and the Constitution. My thoughts around media in terms of fostering national cohesion, I do believe that media is a very important aspect in terms of fostering national cohesion. And I do believe that we have a young generation that is largely tech-savvy, largely well-informed, and I remember in the years 2007, 2008, in the early 2010, 12, hate speech was largely around word of mouth. But now HBID has devolved to a level where everybody has a tab or a phone on his or her fingers, and they can be able to say whatever they want. So I do believe that the Commission has to move to where that space is in terms of media, using the social media, using the mainstream media, in making sure that we are able to also demystify the importance of cohesion. We can be able to counter whatever that is said in terms of hate. We can be able to counter it with positive aspects of cohesion and integration. And I also believe that the Commission can be able also to partner with ICT developers, media houses, institutions that are also trying to foster peaceful coexistence or are implementing important duties. For instance, IEPC, we can be able to partner with them in terms of carrying out civic education in the media, doing talks on the local community radios, so that we can be able to nurture, we can be able to talk about the importance of coexistence, the importance of living together, the importance as a country, because as I earlier said, when you get out of this country is when you will realize that peace is very important. In my work in Somalia, it was not easy. Every day, the person whom you went to work with is no more. So I think we can be able to propagate that if you look at our neighbors, for instance, Somalia, the harm that conflict has done through the media, we can be able to partner with media so that they can be able to be agent of change in creating awareness, in creating peaceful coexistence among Kenyans. Thank you.
The final one, in your school living certificate, your year of birth is indicated as 1987. In your identity card, it's indicated as 1986. Is this the same person?
Yes.
Then the last one, we literally have come to the end of the questions, but I'm going to ask you a question based on your immediate predecessor commission. The outgoing chairperson of the National Cohesion and Integration Commission accused one of the committees of Parliament that none other than the chairperson of the committee solicited inducement in order to grant the chairperson and the commission appearance before the committee. And I want you to go on record and either confirm or deny or negate whether the chairperson of this committee, any of the members of Parliament who sit in this committee, any of the members of the Secretariat who serve this committee, or any proxy out there has approached you and asked you to provide inducement so that you could be granted audience to appear for the vetting before this committee.
Thank you, Honorable Chair. I want to be very categorical and clear on that. There is no time that any member of this committee, whether the chair or the members or the secretariat, have been asked for any inducement from me. And I believe that this is the first time we are meeting. I have not met any one of you, either formally or informally, and there is no time that any committee member, whether the chair or the secretariat or the honorable members of the committee, have reached out for any inducement. Thank you.
Thank you, nominee. We have come to the end of the session. Kindly ensure that all the documents, your original documents, are returned to you by our secretariat. The committee will retreat to begin report writing on your suitability and the suitability of the other members, and that report will be laid on the table of Parliament on Wednesday this week. And thereafter, you will know the outcome based on the resolution of the entire House. We thank you for appearing and for responding. We wish you well.
Thank you, Honorable Chair. Can I make some?
You can make your closing remarks.
Thank you, Chair. Thank you, members, for this opportunity. I have learned a lot, and it was worthwhile interacting with you. And I do believe that moving forward, if given an opportunity, I'll be able to leverage on the experience of the committee in terms of making sure that we have a cohesive Kenya. I will also want to take this opportunity to thank His Excellency the President for nominating me for this position. I do believe that national cohesion matters are very important for this country, and if given an opportunity, I'll be able to deliver on its mandate and try and see how we can be able to have a more cohesive Kenya, a Kenya that is given an opportunity to all in terms of jobs, in terms of resources, and it has been an amazing experience sitting in front of you and learning from you a lot. Thank you.
Thank you. You will only know whether you have been nominated once the National Assembly has pronounced itself on your nomination. You still have the last handle in terms of the National Assembly releasing its resolution on the appointment made by the President.
Thank you, Chair.
Okay. Amen. We will go ahead and introduce ourselves. We'll start with the members of Parliament, then the Secretariat, and then the nominee. I am Duncan Maina Madenge, Member of Parliament, Nyeri Town Constituency, the Vice Chair of the National Cohesion and Equal Opportunity Committee of the National Assembly, and I'll be sharing this session. Members, please.
Thank you, Chair. My name is Oku Kaunya, Member of Parliament for Teso North, and a member of this committee.
Thank you, Chair. My name is Maungu Dick, MP Luanda, a member of the committee.
Good afternoon. My name is Fred Ikana, Member of Parliament, Shinyalo constituency, and a member of this committee.
Good afternoon. My name is Engineer Paul Nzengu, Member of Parliament Mwingi North, which is in Kitui County, and a member of the committee.
And I'm Martin Peters Owino Wood Chief, Member of Parliament for Ndewa constituency, and a member of this committee.
Secretariat, please.
Good afternoon. My name is Wanjiro Mora, Principal Clerk, in charge of the statutory committees.
Good afternoon. I am Nasirian Lotwai, Committee Clerk.
Good afternoon. My name is Joanna Neo, Research Officer.
Good afternoon. I'm Audrey Andala, Legal Counsel. Thank you.
Good afternoon. My name is John Mutinda, Clerk Assistant.
Good afternoon. My name is Daniel Sirmo, Media Relation Officer.
Good afternoon. My name is Amos Tindi, Hansard Officer.
Luca Mutua, Sergeant at Arms.
Good afternoon. My name is Aura Anita Nyambura from the Parliamentary Broadcasting Unit.
Good afternoon. My name is Magdalene Wangari from Parliament Broadcasting Unit.
Okay, nominee, you will introduce yourself.
Good afternoon, Honorable Chair, Honorable Members, and members of the Secretariat. My name is Teresia Jerusa Mwadhime Michael. Thank you.
Okay, Teresia, we will welcome for this vetting session. We will have the Sergeant at Arms administer the oath. Thereafter, you will sign the oath. Then you will forward all your documents, the documents that you have submitted in the course of the application, the certificates and testimonials, to our legal counsel for verification. After that, you will proceed to introduce yourself again. If you have members of your family or a friend or a companion that you have chosen to accompany you, you are at liberty to introduce them. Sergeant at Arms. Kindly confirm your religion for the purposes of the swearing in.
I'm a Christian. I, Teresia Jerusa Mwadhime Michael, do swear that the evidence I shall give before this committee on the matters under its consideration shall be the truth, the whole truth, nothing but the truth, so help me God.
After signing, you'll give your documents for verification. Okay, go ahead, introduction and introduction of any person you have chosen to accompany you.
Thank you, Honorable Chair. My name is Teresia Jerusa Mwadhime Michael, and I'm accompanied by my husband, Joseph Mwangi. He's seated behind there.
Okay, thank you. We are going to be guided in our interactions by the Constitution of Kenya, the National Cohesion and Integration Commission Act 2008, the Public Appointments Parliamentary Approval Act, and the Standing Orders of Parliament. Largely, during your presentation, you will speak uninterrupted. However, should any of the members of Parliament find it necessary to bring something up or to your attention, they will rise on a point of order. When a member of Parliament rises on a point of order, you will halt your presentation, wait for the member of Parliament to execute the point of order, and then the chair will guide on how we will proceed on the point of order. This session will take roughly 1.5 hours. The clock started ticking immediately you entered this room. You will begin by giving us your education background, your employment background, and then you will tell us why you think you are suited for the position whose nomination and vetting you seek. Upon the completion of that, the members of Parliament will field questions to you. First, if they have any clarifications on the basis of the documents that you have presented or the presentation that you will make, they will seek clarifications. And then each member will field to you 2 questions initially. When the members field the questions, you will write the questions down until each one of them has fielded the questions. Then we will give you time to respond. At the end of your response, we'll go back to the members of Parliament If there is any clarification based on the answers you will have presented, they will seek clarification. In the alternative, or alongside that, we'll also field either a supplementary question to what they had asked earlier, or an entirely new question. In the second round, each member will take one question, and then we will review how we have performed in terms of time. Kindly proceed.
Thank you, Honorable Chair. Honorable Chair, honorable members, my name, once again, is Teresia Jerusa Mwadhime Michael. I'm an advocate of the High Court of Kenya and a member of the Law Society of Kenya in good standing. I am a certified professional mediator and a member of the Institute of Chartered Mediators and Conciliators. I am also a certified secretary and a member of the Institute of Certified Secretaries Kenya. Further, Honorable Chair and members, I am a certified legal auditor. Further, I am an associate arbitrator and a member of the Institute of Chartered Arbitrators Kenya. Honorable Chair and members, I have training in counseling and psychology, and also training in strategic leadership and management, specifically on the issue of church leadership. Honorable Chair and members, I was brought up in Ikanga in Kitui South constituency within Kitui County. I attended primary school in Ikanga Primary School, where I sat my KCPE in the year 2007. From there, Honorable Chair and members, I proceeded to the Kenya High School between 2008 to 2011, whereby I sat my KCSE in the year 2011. Honorable Chair and members, from there I proceeded to the University of Nairobi, where I undertook my Bachelor of Laws degree, and I graduated in 2017. Upon acquiring my Bachelor of Laws degree, I proceeded to the Kenya High School for my postgraduate diploma in law, which was done in the year 2018. And from there, I proceeded to be admitted as an advocate of the High Court of Kenya in the year 2020. Currently, Honorable Chair and members, I am a candidate, an Master of Laws, LLM candidate at the University of Nairobi, whereby I've completed all my coursework and finalizing my research paper and awaiting graduation. Honorable Chair and members, as to regards with my employment background, I started working when I was still at the university as a legal and research assistant in a law firm between the year 2014 to 2017. After 2017, after graduating in 2017, as I was in the School of Law, I transitioned to private sector institutions, where I served as a legal officer and also grew to a legal manager and also a legal and human resource manager. In the year 2020, I founded TJ Michael and Company Advocates, which is my law firm, where I served as a managing partner up to around last year, June 2025, when I relinquished that role of managing the law firm to somebody else in order to take up a responsibility at the Executive Office of the President. In the year 2024, I was appointed as a board member of the National Lottery Board. The National Lottery Board is a new institution that was brought up by the National Lottery Act of 2023. It's still its informative stages, but one of the major roles that I and the board members have played as the inaugural board is to institutionalize the lottery board and also ensure that the foundation is strong. I will now proceed to speak. Before I proceed to speak about my suitability, I would like to confirm that currently I work in the Office of the Senior Advisor, Constitutional Affairs and Human Rights in the Executive Office of the President in a technical capacity, as a technical advisor in charge of research, preparing briefs, and basically offering technical support and advisory to the senior advisor on the constitutional affairs and human rights. Why I am suited for this position, Honorable Chair and members. First of all, I wish to confirm that I have the integrity requirements under Article 73 of the Constitution of Kenya. I have presented all the necessary documentation that is required, from the tax compliance certificate to the ESCC forms, and also the health clearance and the necessary clearances. I have also presented the DCIO clearance, Honorable Chair. However, I note that the DCI clearance that I presented is dated August 2025. My understanding was that such a certificate is valid for 1 year. However, I got information this morning that there was need to have fingerprints taken again for the certificate to be issued. I confirmed that I went this morning to DCIO Kiambu, and I had my fingerprints taken once again. And within the documents that I've presented to legal counsel is a receipt evidencing that I indeed presented myself to the DCIO this morning. Honorable Chair and members, again on my suitability, I believe I am suitable to be appointed as NCIC Commissioner because of my legal and constitutional grounding. My professional life, my practice, my career is grounded on legal and constitutional values, which are integral and important for the proper functioning and the delivery of the mandate of the NCIC. Further, my background in alternative dispute resolution is also an added advantage, considering that in this, the Constitution and Article 159 prioritizes alternative dispute resolution, and NCIC would benefit from having methods of dispute resolution that involve mediation, conciliation, peace building, involving the parties, dialogue, as opposed to reactive approaches and enforcement. So that particular experience in alternative dispute resolution is particularly key in ensuring that we have a commission that is more preventive than reactive. That will be all, Honorable Chair and members. Thank you.
Thank you. We begin with the questions from the members. Honorable Ikana, Honorable Maungu, and Honorable Martin Peters. In that order first.
Thank you so much. I start by congratulating the nominee for coming up this far, and also for a very elaborate presentation you have given us. I have a few questions. Number one, as you may be aware, most Kenyans feel that the NCIC Commission is very weak structurally, and some Kenyans regard it as a toothless commission. If this committee considers you for appointment and eventually Parliament approves your nomination to be appointed, what legal and structural changes are you going to propose or recommend so that we enhance the effectiveness of NCIC? Then number two, given your background as a lawyer, I'm seeking to know what legal threshold must be met for speech to qualify as hate speech, given that, again, our very constitution gives Kenyans express freedom of expression. Then finally, what legal safeguards must NCIC follow before recommending prosecution to avoid violating fair trial rights? Thank you.
Honorable Maungu.
Yeah, thank you, Chair. Allow me also congratulate the nominee for coming this far. Madam Jerusa, you have a very elaborate CV. An advocate of the High Court of Kenya, a constitutional and human rights law expert, a certified secretary, an arbitrator and certified professional mediator, a court annexed mediator, a certified legal advisor, leadership and management experts, and a certified counselor and psychologist. All those describe you.
Yes.
Help us understand that while your CV demonstrates extensive experience in mediation and legal practice, provide specific verifiable instances where you have directly handled inter-ethnic or inter-community conflicts, and explain the outcomes and the lessons drawn from that scenario. Number 2, NCIC's work involves investigation, enforcement, public education, and policy influence. Which of these areas do you consider you are strongest? Which of these areas do you think you require further strengthening? And how do you intend to address that gap? Thank you.
Honorable Martins.
Thank you, Chair. And thank you, nominee, and also I want to thank your spouse for giving you support. I think that's a good example. Question number 1, having been, or you are technical advisor at the presidency, that's the highest office, why would you relinquish that to just be a commissioner? Number 2, you just mentioned that when you had relinquished management of your firm, the law firm, but you did not tell us the ownership. Did you just relinquish the management and retain the ownership or not? Number 3, I think my colleague alluded to this. Article 33, freedom of speech. Where would you draw a line between freedom of speech and hate speech? And what is your understanding of hate speech? Maybe some attributes, if you can. And the last one, in order to achieve transformative...
Honorable Martins, I'll lure you out of order according to our procedure. 2 questions first. I've allowed you the liberty of a 3rd one. So kindly allow the nominee to respond to those ones that we have fielded. Nominee, please proceed.
Thank you, Honorable Chair. Thank you, Honorable members. I will begin with the question by Honorable Ikana on the aspect that NCIC is perceived to be weak to have a weak structure, and most people refer it to toothless commission, and what legal and structural changes I would propose to ensure that NCIC is able to be strong. Allow me, Honorable Chair, to begin by stating that the NCIC Act came into place in the year 2008 as a reaction to the 2007-2008 post-election violence, and therefore it came before the 2010 Constitution. Therefore, one of the biggest challenges is that the Act is not grounded on the 2010 Constitution. For instance, you will see that the NCIC Act actually has 20 functions under its mandate. In my reading of the Act establishing the several independent commissions in Kenya, I think the NCIC Act is one that has one of the broadest mandates. In fact, if the NCIC was to actually implement and take up those 20 mandates that are in its act, it is one of the most powerful commissions in the country. However, implementation has been a problem because if you look at the Act, for instance, it's supposed, with the dispensation of the 2010 Constitution, it's supposed to operationalize Article 10 of the Constitution, Article 27, Article 232, and and basically, you know, Article 73 of the Constitution. So this act having come in before the 2010 Constitution, you find that its mandate and the structural alignment and also enforcement mechanisms are not really grounded in the 2010 Constitution, making it a bit difficult for it to properly deliver its mandate effectively. Other than that, I believe there is currently a bill before Parliament, the NCIC Bill 2023, which is under consideration. I have had an opportunity to look at that bill, and my opinion is that that bill, yes, it is a strong bill, because now it actually links now the aspects of national integration and cohesion to the 2010 Constitution, and introduces and rewards its functions and enforcement mechanism in line with the 2010 Constitution, and also in line with the current challenges that are there. I've been asked what legal and structural changes I would propose. Now, in light of the fact that there is that bill already in Parliament, I think the most important thing is to look at whether that bill actually addresses this issue, whether it is sufficient, and whether much can be done to it. I will note that nowadays, if you look at that act, it mainly focuses on hate speech, for example, made in political rallies. It focuses on publications. If someone publishes something in writing, it focuses on utterances. But it does not really envision the current situation whereby hate speech, incitement, and violence is mainly done on the social media, using social media platforms, using TikTok, WhatsApp, and all those digital platforms that are available. So I feel even the new bill still needs to be strengthened in terms of enforcement in the era of digital. In this digital era, it needs to be properly strengthened so that there are proper evidence collection and evidence preservation mechanisms, because collecting digital evidence, we have the Evidence Act, and you might find that if someone records a video, if someone takes a photo, the evidentiary standards that are required at the law may not be met, and so you find that most of those people might actually go scot-free. As I've said, the Act is progressive and could solve this issue. There are two, however, weaknesses that I've noted, and because I'm before this committee, I think this is the best place to just note that the current NCIC Act is very clear on the independence of the NCIC. Under its powers, it says that the NCIC is an independent commission, and it shall not be subject to direction or control by any person, government, or authority. However, that is actually conspicuously missing in the new bill. The powers that have been given to it, somehow that clause has been deleted that gives the independence of the commission, and so in my legal capacity, I think that is one of the proposals that I would make, because NCIC needs to be strengthened and not watered down. NCIC is one of the institution that could properly operationalize the 2010 Constitution, especially on Article 10 and Article 27. So it is a commission that needs to be supported and needs to be given its independence as strongly as possible. I also noted that the current term in the NCIC Act is a non-renewable term of 6 years. And I believe the reason as to why these independent commissions and offices are given this non-renewable term of 6 years is to promote the independence and ensure that officers are not acting with fear because they are within maybe the same electoral cycle, so that by the time those 6 years are over, it spills into another administration, and officers are able to perform their independent duties without fear, without trying to work for reappointment. But the current bill provides for 3 years, renewable once. So again, it sort of takes that independence away from NCIC, and it becomes more than like the other boards. Most boards, it's 3 years, a renewable one. So those are in my legal capacity, those are some of the issues that could be addressed to strengthen the new bill. But otherwise, I think the new bill would really help to assist NCIC. The other thing is also the issue of enforcement. You find that currently the NCIC really relies on complaints that have been forwarded, and it also relies on other institutions to be able to perform its most of its duties. So for me, I would strengthen collaboration. I would strengthen collaboration with institutions, with other institutions in the NCIC. I know most people would argue that because NCIC does not have prosecutorial powers, that is why enforcement is weak. However, the Constitution of Kenya under Article 157 clearly provides that prosecution is a mandate of the Office of the Director of Public Prosecution. So all these independent commissions, including EACC, do not actually have any prosecutorial powers, because that is a constitutional duty of the ODPP. So the solution lies not in giving prosecutorial powers, but ensuring that NCIC is able to properly conduct its investigation, its evidence gathering, and properly collaborate with ODPP, DCI, National Police Service, and other institutions to ensure that cases that are forwarded to ODPP for prosecution are proper. But most importantly also, it's good to move away from enforcement and be preventive rather than reactive. And this can be done by ensuring that we have early warning systems, early detection systems, which will be able to prevent violence and ethnic polarization before it actually happens. I will now proceed to the second question on the legal threshold that must be met for speech to qualify as hate speech. Hate speech, I think, is one of the most understood concept of NCIC. Article 33 of the Constitution gives the freedom of expression. In a democratic country like ours, the freedom of expression is a right under the Bill of Rights and must be protected by all means necessary. So for speech to be hate speech, there are some thresholds that have to be met. There should be an element of ethnic incitement, spreading of war or propaganda, messaging that is supposed to stir ethnic division, ethnic hatred, and all that. In fact, those are exemptions that are clearly and properly provided for under Article 33(2) of the Constitution. So that those exemptions must clearly be met before freedom of expression is actually curtailed. And so there is need to ensure that there are clear mechanisms and clear and transparent processes of identifying hate speech, understanding the contexts in which it was spoken, how it was spoken, what it was meant to do, so that the underlying message is very proper, so that we do not have situations where freedom of expression is curtailed, but also we must ensure that freedom of expression is acted and done within the constitutional angles of ensuring that it does not lead to ethnic incitement, polarization, disinformation, misinformation, spreading of propaganda, and it should not make one community feel targeted as opposed to another community. The other question is, what legal safeguards must NCIC follow before prosecution to avoid violation of rights? I think these two go actually together. The issue of first ensuring that there is proper evidence gathering before any action can be taken. I understand that gathering evidence sometimes might be very difficult, especially where Kenyans are very clever. You know, somebody can say something which is clearly which is being understood by many as being hate speech, but then they have their own interpretation, which they can always have an explanation. So I think I noticed that the NCIC Act, in as much as it came into place in the year 2008 and provides for regulations under it, there are currently no regulations, and this is very many years later, over 15 years later, I think. We still don't have regulations under the the current NCIC Act. And I think regulations will be able to establish standards, establish clear procedures on how to handle hate speech, how to do the summoning, what is the threshold, and that kind of thing. Because, you know, the law establishes the law, but then regulations are actually able to operationalize that. And so I think one of the biggest challenges we have is that operationalization of the NCIC Act. So also applying a one standard to all, you know, ensuring that those standards are applied to everybody so that there is public trust in the institutions. But most importantly, the safeguards that must be put in place is to ensure that all the relevant actors are brought to board, because relevant actors have different capacities and different information that they can bring to strengthen a case before it's taken to the ODPP. Because the ODPP basically receives a case and must review that there is a strong case on a balance of probabilities before they can take the matter for prosecution. So if a weak case is presented before the ODPP, they cannot prosecute it, and it has nothing to do with the ODPP. It has everything to do with how the evidence that has been presented. So there is need for collaboration with, first of all, maybe the Communications Authority of Kenya, if it's matters of digital incitement, collaboration with the DCI, collaboration with the National Police Service to ensure that we have a strong case before it's presented to the ODPP for prosecution. I think that will be it from Honorable Ikana. Yes, thank you, Honorable Ikana. Allow me to proceed to Honorable Dick Maungu. His question was that, to understand, okay, thank you. Sorry, my handwriting, I was writing in a hurry. So that I think Honorable Maungu wanted to understand the specific verifiable instances where I've handled inter-ethnic conflict, the outcomes, and the way forward. I would say that as a legal practitioner, I wouldn't say that I have specifically handled inter-ethnic disputes involving different communities whereby the exact subject matter is ethnic disputes. However, I have handled very many matters whereby as a practitioner and as a court annexed mediator, I am a court annexed mediator. And as you're aware, court annexed mediators, we are usually referred to cases by the judiciary for mediation, and then after mediation, we do our reports and then submit them to the judiciary for basically dispute resolution. It's a form of alternative dispute resolution. And in my handling of many of the cases that have been referred to under court annexed mediation, I've been able to handle complex issues, matters involving complex land issues, complex family issues, complex succession issues, and even commercial disputes. And I've been able to get a favorable settlement by listening to the parties, by being able to identify the root causes. One of the things that I've learned about mediation is that most of the time, the issue is not just what you think. There's always underlying issues. And when you're able to identify the underlying issues causing problems and conflicts, then it becomes easier to actually assist the parties reach an amicable situation, because mediation is a win-win, is basically supposed to achieve a win-win situation where both parties feel like they have actually won, and that way it prevents the dispute from continuing further. So I believe with that experience of practical dispute resolution in terms of especially my experience in court annex mediation would assist me in handling inter-ethnic conflict outcome that I would come across in the course of my role as NCIC Commissioner. The other question that I was asked by Honorable Maungu is the issue of investigation, enforcement, and public education, which is my strongest, and further how I'll plan to address any gap that is there. Yes, it's true. NCIC work involves investigation of matters, of course, in collaboration with the relevant state agencies, and also enforcement through compliance notices, through hearing, and the hearing, and then through compliance notices, which are usually can be enforced through the magistrate court, and also public education, which is basically youth sensitization on matters national cohesion and integration. I would say that, of course, the strongest asset that I would bring here is public education, because this is basically promoting sensitization and literacy. I think Kenya is a country that is craving and thirsty for knowledge and information. And most of the time, Kenyans benefit from misinformation and disinformation, and that is why some of these things might erupt into violence, and these are things that can actually be prevented. So I think how I would strengthen public education is to leverage on existing platforms. For instance, I will say confidently here that I am actually a youth under 35, and the biggest population in Kenya constitutes of the youth. I think 75% of the Kenyan population is under 35 years, and within that, around 29 to 30% are actually youth. And this population is a population that would like to be heard. It's a population that is at a place where they don't want to just be talked about. They also want to speak. They also want to be heard. They also want to be listened. The only problem arises that most of the time, the information that reaches the young people is information that has actually been watered, or rather is not accurate. So I think having youth engagement, youth empowerment, youth sensitization forums, and youth engagement is one of the aspects that would really benefit the national cohesion and integration in the country. And also just general education, collaborating with the necessary agencies to ensure that we provide education. I think it will also benefit, because I think, if you allow me to say, politicians, I think, are the biggest clients of the NCIC. And so one of the, in this public education, it's important also to involve political actors in conversations, in sensitization forums, perhaps have even an Amani conference, or ushirikiano na umoja, cohesion and integration conference, or something that brings together all the political actors from every divide, and just talk about, and just, you know, be educated in sensitization, and have a dialogue around national cohesion and integration, and be able to make decisions that can be collectively owned. Because I think instead of, for instance, NCIC saying that it is illegal for you to mention a certain ethnic community when you're speaking, it's illegal to say certain words, or it's illegal to do certain actions on its own, as opposed to being a collective decision. If it's a collective decision between all the political actors, for instance, when the members of parliament, all of them, and senators, governors, all the leaders get together in a room, or their leadership, and make decisions collectively on what is proper, what can be said in rallies, what cannot be said in rallies, what are the tenets, and come up with something. You know, they will own it, and it will be easier to enforce and live by that document, as opposed to just being given criteria and tenets to abide by. So just working with the institutions, I think that will be good. I think that will be all for Honorable Maungu. Thank you. Allow me to proceed to Honorable Martin's question. His question is why I would like to relinquish my role as a technical advisor to be a commissioner, and also on the issue of my law firm. I've said I relinquished management. So I will clarify. First of all, as a technical advisor in the Office of the Senior Advisor, Constitutional Affairs and Human Rights in the Office of the President, my role is mostly technical. That means, as the name suggests, actually, it's basically research, preparing reports, preparing documents, and preparing briefs that assist in living the constitutional interpretation and implementation of the Constitution of Kenya. I believe that this role at NCIC is not really moving away from that job as a person who deals with constitutional interpretation and implementation, but it's actually living the Constitution. It is an opportunity to actually live the Constitution, directly interact with the Constitution through NCIC. As I earlier on stated, I think NCIC is one of the most important commissions because it operationalizes most of the foundational articles of the Constitution of Kenya, which is Article 10 of the Constitution, 27 to 32, and all those other articles that are operationalized by NCIC. So I believe that I am basically moving to implement the Constitution in a more direct manner, and career-wise and professionally, and as a lawyer who is passionate about Constitution and the law, I think that is a good place to be. I would confirm that, yes, I relinquished management of the law firm, but I am still an owner in the law firm.
Nominee, I want to give you guidance.
Yes.
Looking at our time, half of the time is gone. Half of the members have not asked questions, and there will be clarifications and supplementary questions. I'd like you to be a little bit more brief without losing the key points in terms of your responses.
I am very well guided, Honorable Chair. I think I will just wind up. The other question Honorable Martin had asked was on the aspect of Article 33 on the freedom of speech and hate speech and understanding of hate speech. I think I actually answered that question when I was addressing the first question, but I'll just repeat it in just briefly and concisely that Article 33 on the freedom of expression is very clear, and however there are exemptions that are very clear, and that is propaganda to war, incitement to violence, ethnic division, and polarization. Thank you, Honorable Martin. Thank you, Chair.
Honorable Engineer Nzengu, then Honorable Kaunya.
Thank you, Chair. I also want to join my colleagues in congratulating the nominee for the presentation. I'm actually very impressed by her educational exploits, even as a young woman. Having said that, I want to ask clarification from her, or maybe her opinion on certain things that have happened in the past. One, as you aspire to become a commissioner, I want to put an experience that I had to you and tell me whether it was a right experience or it was a right thing to do, and if it was not right, because I believe it was not right, how would you correct it if you become a commissioner? At some point, Chair, I held a family meeting with family members, and just someone came in and found us having a discussion. And the discussion was, I had just been elected, and some people who were against me were talking like, they were trying to harass my people. And we were trying to keep quiet because we were trying to prove to be within the law. So when that discussion came up, I told my members that we cannot, yes, we are not going to provoke people, but we are not going to wait until somebody puts a finger into your eye. So if that happens, we have a right to protect ourselves against such aggression. And so someone picked that clip and gave it to my predecessor who had beaten in that election. And because he had been a member of parliament before and had a relationship with the commissioners, immediately I was converted to be a client of NCIC, and I was subjected to a lot of investigation unnecessarily. And for me, that thing was not right. If it is right according to you, you may as well tell me. And otherwise, if you feel it was not right, then what would you do so that we have a certain threshold where if someone is under investigation for hate speech, at what level would that person be summoned to come and maybe present themselves to the commission? Because you cannot just summon someone whom you have not done complete investigation for you to now come and verify whether whatever information you have is actually the one that is reported. So that is one. Number two, you come from Kitui County, and there has been a conflict between the Somali community and the Kamba community, particularly in Mwingi North, Mwingi Central, and Kitui South. And now that you're asking to become a commissioner, this is going to be one of the key agenda that you'll be expected to address. And your predecessors who have been sitting here, I've asked them the same question. However, now that you come from Kitui and your people are aggressed, do you think you will be in a position to be fair and neutral when it comes to dealing with matters that touch very deeply into your community, and more so the fact that now in my constituency I'll be burying 7 people in the next 1 week who are killed in cold blood by the aggressors from the Somali Kamohadas. Do you think you will be neutral enough to address or to be able to arbitrate between the two communities? Thank you, Chair.
Honorable Kaunya.
Thank you, Chair. Chair, I want to join my colleagues to congratulate the nominee for having moved this far. But I really want to emphasize that she is 32 years old, and when you look at the experience and the academic achievements, they are quite great. It's commendable. So I wanted to say one of the questions that bothers this country as we go to the election, and even in the past elections, has been the question of goonism. Now it's popularly known as goonism, or the use of gangs by politicians in elections or in campaigns. As a youth, in that case, because you are below 35, what strategies, practical strategies, would you bring on board if considered as commissioner to address this matter of goonism and gangsterism within the political space? Secondly, I want to ask a question related to your profession as a legal expert. Would you consider that the Kenya Constitution or some sections or parts of the Kenya Constitution are a threat to national cohesion in Kenya today? And which part, perhaps, and you get the point.
Sorry, I was actually...
would you consider that some parts of the Kenya Constitution are a threat to national cohesion in Kenya today? And if so, what aspects and what threats?
I'll have 2 questions for you. The first one, alongside looking at the matters of inter-community conflict, in your presentation, you seem to only see that hate speech refers to ethnic mobilization or incitement. Within the same community, within the Kikuyu community, within the Kaba community, within the Luo community, can we have hate speech? Where one Kikuyu is speaking about another Kikuyu, one Kamba is speaking another Kamba, one Luo is speaking about another Luo. I've given those as examples. And then what are your thoughts about dealing with that inside the same community? Is it possible to have hate speech? The second one in the same area, ethnic diversity in this country as a tool for cohesion and inclusion, and especially your ideas around the area of the systemic discrimination in public institutions in terms of employment, even...
Chair, sorry, I got distracted. I was being told to switch off the mic.
Okay.
If you can kindly just start the question again, I would appreciate it.
The first one.
No, the second one, Chair. Thank you,
The issue of ethnic diversity as a tool for cohesion and inclusion, especially focusing on the enforcement of equal opportunity in public employment and systemic discrimination in public institutions. Then lastly, I want to focus on the role that you have played as an advisor to on constitutional affairs. You are aware of the NADCO report. This report was presented to Parliament in November 2023, and sometimes in November 2024 it was adopted. Among the recommendations in the NADCO report on matters cohesion was a proposal to merge 3 commissions: the NCIC, the National Gender and Equality Commission, and the Kenya National Human Rights Commission. In that adoption, Parliament gave a timeline of 1 year for its implementation from the time of adoption. That 1 year expired in August. Now, you're here seeking nomination into a full standalone NCIC. Yet, alongside the NADCO report's implementation, we expect at some point the creation of this one commission that combines the 3 of them. On the basis of your experience as technical advisor on constitutional affairs, do you think then Parliament should give conditional approval to the reconstitution of the commissioners of the NCIC? Thank you.
Thank you, Honorable Chair. Thank you, Honorable Members. Allow me to start with the questions by Honorable Nzengu. And before I proceed, Honorable Chair, allow me to acknowledge the congratulations that I've received from the members, starting from Honorable Ikana, Honorable Maungu, Honorable Kaunya, and Honorable Martins, and now Honorable Nzengu. I would also like to appreciate the recognition that Honorable Kaunya has given me. I take it with humility and gratitude. Thank you so much. The Honorable Kaunya has raised the issue on goonism, the use of gangs by politicians in elections, and would like to know, as a youth, what are the practical strategies that...
Nominee, we have been following a specific sequence. I'll request you, if possible, to stick to it, that you respond to the questions in the order in which they were raised. Before Honorable Kaunya were the questions from the Honorable Engineer Nzengu.
Thank you, Honorable Chair. Actually, that was an oversight. Yes, I will start with the questions by Honorable Nzengu. First, on the issue that he raised on the right to protect, on the conversation that he was having, and somebody had or recorded it, and he became subject of investigation by NCIC. I think this is one of the issues that I was talking about, on proper and clear enforcement mechanisms and proper and clear threshold for hate speech. As I had said before, we have the law on hate speech broadly and generally, both in the Constitution of Kenya and also in the NCIC Act. I believe it should be Section 13 or something. But the law on hate speech is broadly there. But then the operationalization of that law has not yet been done clearly. And I believe it will be necessary to have a proper threshold that is actually anchored in law on what are the elements, what are the key factors that need to be taken into account for speech to be considered to be hate speech. What are the requirements, what are the ingredients of hate speech? They should be listed, who is the audience, so that if I'm having a conversation like Honorable Nzengu was having with colleagues, is that is that hate speech, or does it need to be like defamation? It should be information that has been consumed by the public. Should it be information that has been said in a public forum or in a place where many people would access it? That differentiation between hate speech in political, in a public setting or in a private setting. So those are some of the lacunas and the gaps that we have in law that need to be established, so that there is a proper threshold as to what comprises of hate speech. I would say I would avoid commenting whether it was right or wrong to NCIC, for NCIC to summon the honorable member, because I am not privy to the details therein. But I would say that sometimes I believe summons can be to assist in investigations, so that if something has been said or reported under the Act, the Commission, if there's a complaint that has been made, they have a responsibility to ensure that they have actually followed up on that complaint. And one of the factors would be to summon a member or an individual to furnish further particulars, so that to aid with the investigation, so that the summoning is not itself saying that a person is guilty. The summon is not declaring that that person engaged in hate speech, but the summoning is basically to assist with investigations and to actually establish whether or not there were elements of hate speech. The other issue is the issue of the Kitui, Somali, and the Somali and Kamba community disputes. And the fact that I come from Kitui, whether I would be in a position to be fair and neutral, especially because the matter is touching my community, and whether I can be able to arbitrate between the two communities. First of all, allow me, because we are here and this matter is live before us, I would like to pass my condolences to the families of the victims of that attack, the 7 people who are dead. And I think one of the most important aspects is to ensure that the concerned security agencies take the necessary measures to ensure that the people and the perpetrators are actually brought to justice. Now, flowing from that, I would like to say that I think as a member, if appointed as and approved as a member of NCIC, the first thing would be not to rush and declare disputes as ethnical. Yes, it is a dispute involving the Kamba community on one hand and the Somali community or on the other hand. However, I think it was actually Tana River. I'm not sure. I think it's Tana River. Yes, it's Tana River. But I wouldn't rush to declare that an ethnic, ethnic violence or a matter stemming out from ethnicity, because there are underlying issues. You know, when you use the term ethnicity, if not used carefully, it could actually elicit more violence, because when you talk about Kambas, you talk about all Kambas. There are Kambas in Makueni, Kambas in Machakos, and in other areas of Kitui that are not part of that. And same to Somalis. There are Somalis in other areas who are not part to that dispute. So that when we refer it to Kamba and Somali, it brings the danger of involving the whole community and making it an ethical issue, which could actually now trigger more violence, because now it becomes a matter of ethnic identification.
Point of information, Chair. Chair, we are very specific on what communities we are talking about. We are talking about Somali camel herders who are herding their camels in Kitui County. And we are talking about the Kamba farmers who are also farming around the same area. So we are not generalizing, saying Somalis and Kambas. We are very specific, just for information purpose.
Thank you very much for that clarification, Honorable. I think I would go now to the next point, just supporting that aspect, that the most important thing is to identify the root cause. And I think you have, Honorable Nzengo has clearly stated the root cause, because the root cause might not even basically be about those herders, those Somali herders or those Kambas who are farming there, but it is a matter of scarcity of resources. You could find that it is a matter of inadequate resources in terms of water, in terms of pasture, in terms of the resources that both communities need for their people. So that the best approach would be to look at the root cause, to look at what the exact problem is, and find solutions to that root cause. When solutions are found and empowerment and resources are actually available to those communities, it will be important to ease the tension. Further, I think it will be important to promote dialogue between the communities, and dialogue that actually involves not just all the actors, from the victims of the affected families to the people and leaders, religious leaders, political leaders from both divides, and try to come up with a community solution. Honorable Chair, I think on the issue of whether I will be in a position to be fair and neutral, to arbitrate the two communities, I believe that is one of the tasks that NCIC should actually be doing even at the moment. There is need for grassroots presence of NCIC, so that when these things are happening, before they actually split over and become violence like what we are witnessing, they can be actually tamed earlier. Because I believe for this, I think I saw that this attack was a retaliation. So that this retaliation is something that could have been anticipated or expected. And so it is important for NCIC to actually have that grassroots presence, and also, even if the grassroots presence is not there, to actually send to send people to the ground and try and identify these issues before they actually become violence, to mediate, peace build among the communities, and find solutions and ways in which both communities can actually share resources or act in a way that does not eventually spill over to violence. So I think it is one role that NCIC could do for that. Thank you. I think that will be it for Honorable Nzengu. Thank you, Honorable Nzengu. I will now proceed to Honorable Kaunya on the issue of goonism and use of gangs by politicians in elections. I think we all agree, and as you've clearly stated, the youth population is one of the most, is the population that is mostly targeted by people who want to use them as goons and gangs. And it's mostly because of the position. You know, there's a lot of youth unemployment, so the youth are vulnerable. They are in situations where they actually, consumers of disinformation, misinformation, and political polarization and radicalization. So that you find that these goons and gangs are basically products of radicalization. And again, I will go once again to the issue of the root problem. So that first of all, we identify why is it that things are happening the way they are. Why do politicians need gangs, for instance? Can we have a way whereby politics is done in a way that gangs will not be required, and interactions in the political circles is more peaceful and orderly than the need to use gangs. Another thing would be putting into place proper empowerment forums. I believe an empowered nation, so that when these politicians or other people try to look for goons and gangs, none are available because they have been involved in empowerment activities, in activities that actually help the youth generate money, activities that help the youth use apply their minds, because I believe we have a generation of Gen Zs and young people who are very brilliant, but they have nothing or no work to do with their brilliance. So finding ways of engaging this youth and young people so that they are busy and they do not have time for these things. Another thing would be, of course, enforcement of early warning and prevention mechanisms, so that there's collaboration between NCIC and the enforcement agencies, the police service and the DCIO, the DCI basically, to ensure that these trends are identified early in advance before they actually they actualize, looking to ensure that if it's gangs and goons, they are actually eradicated early in advance, and proper enforcement mechanisms and penalties and punishment for not just the goons, but leaders who actually use goons and gangs. I would also talk about leveraging on social media for counter posts, countering the negative narratives, so that social media is a tool that young people are really using to consume information and also to disseminate information. The youth one could say that they are the danger in terms of this aspect of use of gangs and goonism, but also there's the solutions. So that because the youth are also the solution, if we find a way of reaching them early in advance and having narratives, counter narratives, using social media platforms that promote cohesion and integration, then this is something that can be dealt with. The other question by Honorable Kaunya was whether I would consider some parts of the Constitution to be threat to cohesion, and what aspects and what threats, and how I would address it. Let me start by saying I think the Constitution of Kenya 2010 is one of the most progressive constitutions that we have as an African country and as an African democracy. It borrows a lot from the United States, and so you find that most of the key provisions and borrow largely from the Constitution of the United States. Now, in being progressive, I believe that the Constitution is a document that walks democracy, talks democracy, and speaks democracy. However, there are a few things that could be improved. For instance, in the previous dispensation before the 2010 Constitution, we had an office of the leader of opposition and an opposition. So that where there is an opposition, there is an office, there's a clear mechanism of conducting business, and there was some sort of structure around it. In the current Constitution, we do not have that, and I believe that is one of the areas that is a threat to cohesion, because we have a winner-takes-it-all constitution, and when there is a winner-takes-all constitution, it means that people who do not win might feel left out. Communities who do not win elections might feel left out. People who don't take up leadership might feel left out. And this is a threat to cohesion. However, if we have a situation where there is a win-win situation between political parties, so that the people who lose the elections, there's some sort of representation for them, that would boost cohesion. I think the other issue I will talk about is the aspect of equality versus equity. You will note that before the 2010 Constitution, most of the marginalized communities and people did not have access to proper service delivery, proper education. Of course, the Constitution brought up devolution, which is a very big plus, and services and education and infrastructure has been able to reach the most marginalized. However, there is there is now the introduction of aspects of equalization fund and aspects of ensuring that there is regional balance in appointments. Okay, I think in as much as it's a good thing, we have found that interpretation is being used. You find that every time there is anything that is being done in government, there is a consideration, and someone who is qualified might be passed on simply because they come from a certain region, and that region has many officers. And I think that is a little, could be interpreted as a threat to cohesion. I think it is ripe to look at the Constitution holistically and look at how we can improve. You know, it's been there since 2010. I think it's 16 years down the line. It is ripe for some considerations of amendments where necessary. Thank you, Honorable Kaunya. That will be it. Thank you. I will proceed to Honorable Chair. Honorable Chair, on the issue of inter-community conflict and inter-hate speech and how to deal with intra-hate speech. Kenya is a very diverse nation with more than 42 ethnic communities. And within those communities, again, there are still linguistic separations, so that you find that in certain communities, for instance, if it's the Luyas, there are classifications of the Luya community, Abagusi, Abawanga, and others. You find that, Bukusu, and so on. So you find that they might be speaking different languages. You find that also there's a community called the Kalenjin community, but there are several sub-tribes to it. And so, yes, I would say it is possible to have intra-community hate speech. And intra-community hate speech would happen where one sub-tribe incites violence and ethnicity between those different sub-tribes. And on the issue of ethnic diversity as a tool for cohesion and enforcement of equal opportunities for employment, and also the issue of ethnic balance, I think currently the NCIC Act recognizes that in all public institutions, employment should not be more than a third of one community, so that that ensures that no community has more than 33% of people, no organization has more than 33% of people employed from the same community. I think the current bill before Parliament actually takes it a little bit higher and does a fifth, 1/5 of the employees in any public institution should not be from one ethnic community. So then, in the matter of enforcement of equal opportunities for employment, there are two aspects. We have very many. We have a diversity, ethnic diversity, and the population and the composition of different communities is different. So that you might find that a certain community has a very large percentage of people as compared to another, then what is the threshold then in an organization whereby we are talking, let me just give rough figures, there's a community that has 10,000 people and another community that has 1,000 people. How do we achieve balance in terms of equal opportunities? It cannot be, we need to have 50 people from this tribe and 50 people from the other one that has 10,000. So that the enforcement should deal with the issue of proportionality to ensure that there is proportionate consideration in employment opportunities. Let me talk about the issue of equality versus equity. Equality is basically where you say equal opportunities. If it's 30%, if it's 2%, it should be this percentage for different people. But equity is taking care of the extraneous factors that are there. So that, for instance, if a certain community, for instance, has a higher composition of people, then the threshold for that community should be higher as opposed to the other community. I can see, Chair, you're looking at the time. I am well guided. Even I will proceed quickly to the issue of the NADCO report. You have stated that the NADCO report, it was adopted in 2024 on matters of cohesion, and one of the recommendations is to merge NCIC, GEC, and NGEC and KNHCR as one commission. Let me say that the Kenya National Human Rights Commission, first of all, is a creature of the Constitution under the Chapter 15 Constitutional Commissions. And from the KNHCR is the one that is created by the Constitution. Then from KNHCR, there's two constitutional commissions that emerged from KNHCR. That is CAJ, the Ombudsman, and NGEC now. Those two branches are children of KNHCR, so that if it's a matter of taking it back, then there are several statutes that would have to basically be dealt with. And we know the law processes and the legal making processes by the law making procedures by the Parliament and the dissolution procedures by Parliament. I believe from where I sit, all these institutions, and there was a reason why the makers of the law found it necessary to actually have those two institutions born from KNHCR. Now, NCIC is a bit different because it came before the 2010 Constitution, and it plays a very critical role. I think on this, I would disagree with the NADCO report, because I think these commissions play very critical parts and in the dispensation of the 2010 Constitution, because each operationalizes specific provisions of the Constitution. As we know, the Constitution, it is the Constitution of Kenya that has given birth to basically all the laws that we have in the country, and the laws are there to operationalize the Constitution. Each operationalizes something different. The Kenya National Human Rights Commission, for instance, operationalizes the Bill of Rights and specifically Article 59 of the Constitution. Then we have the CAJ, that is Ombudsman, which is basically about public service, ensuring that public service organizations do their duties as they're supposed to do, which I think is also unique and operationalizes the aspect of Article 232 of public institutions adhering to the Constitution. And then we have NCIC, which operationalizes the issue of Article 27 on non-discrimination, Article 33, and Article 10. So that if you look at all these institutions, they have a specific role that they play, and I think it is necessary to have all of them, in my opinion. So I think on the issue of conditional approval, as I would say that since the legal statutes are still in place, they have not been repealed, they have not been replaced. The law would, I don't think there's a situation whereby the law would allow for a conditional approval. unless because you know the NADCO report is basically recommendations, and recommendations cannot take precedence over the law itself, so that unless those recommendations are actually operationalized through the parliament, then the current status quo in terms of the existing legislation stands. Thank you, Honorable Chair.
Okay, members, we have literally 10 minutes, so any clarifications?
Yes, Chair.
Substantiation. Okay. Honourable Martin Zawino.
I just need clarification on this. You said something which, that if you are in office longer, maybe your autonomous or performance increases. That is the difference between 3 years renewable and 6 years. You need to clarify that, because if you don't, others may say increase the presidency from 5 years to 10 years. And is that based on research? Because I know you are research oriented, or is just a pronouncement? Thank you, Chair.
Honorable Maungu.
Thank you, Chair. Just to appreciate the feedback, the responses from the nominee. Chair, the nominee is largely young, and maybe that category of Gen Zs, and she acknowledged that she is below 35 years. She went further to confirm that 70% of our population is youthful, which is a good thing. And I think among the nominees we have been vetting, you are the youngest of them, and therefore good for that part. We find that the digital space has been a platform through which a lot of accusations and counter-accusations have really taken toll. And that space is occupied by the Gen Zs, the young, or the group that you represent. Now come a time that you are now going to the Commission as a representative of this group of young people, where we have a lot of hate speech being spewed on social media every other day, a lot of ethnic profiling, cyber bullying and attacks. How do you intend to use your platform as a legal expert on these other sides, as a youth on these other sides, and now sitting on a commission that's supposed to bridge this gap and ensure that the digital forum, the digital forum is used properly? So I wish to hear how you intend to use your advantage of age and the group that you associate with to ensure that we champion cohesion in NCIC. Thank you.
Nominee, I just want to buttress the observation by Honorable Martin Zawino. Independence against security of tenure. And there is a question: if the performance is wanting, why should Kenyans, why should an institution or a person continue to enjoy security of tenure? Yet we live in an era of performance contracting and performance measurement. Proceed, please.
Thank you, Honorable Chair. Thank you, Honorable Martin and Honorable Maungu. I will start with the question on clarification by Honorable Maungu, and Honorable Chair, allow me to merge it together because it speaks to the same issue. Let me say that the essence of independent constitution is to give, the reason as to why this security of tenure was given is to ensure that people who take up these positions do their work without fear and without wanting to impress the appointing authority for reappointment. So that if you are appointed within a certain election cycle, you are sure that you can make impartial decisions. If performance is not good, there are provisions on removal. You know, the security of tenure is not cast on stone. If there are issues of non-performance, if there are issues of gross misconduct, if there are issues of illegalities, that security of tenure is not cast on stone. There are proper procedures that have been laid down both in the Constitution actually and Chapter 15 on how a commissioner should be removed from office, an independent office, and also the acts of parliament that establish the different commissions, including the NCIC, have a clear set out procedure on how to remove somebody from office.
Point of order, Chair. Through you, Chair. We all know what we want to hear from you, maybe from research. Is there any correlation of being autonomous or more autonomous if you stay longer in the office? And before you, we also had a question here, whether we have barometer to measure the spine or backbone. The office you are aspiring for is not for advocates in that perspective, but for people who have backbone and can stand the ground and can withhold all the pressures from above, or VIP, whatever it is, and still do the right things for Kenya. So the question was, if you allude to that, do you have any tangible evidence that if somebody is given long term in office, then that office might be more autonomous? But how about if this guy is complacent because of some reasons and you stay with him for 6 years?
Nominee, I want to draw just one parallel on this security of 10, the 6 year. The 6 year term, non-renewable, is basically security of 10. And the question of independence and the performance of the office of the ODPP. For example, in terminating, this office gives clearance for a case to be instituted and prosecuted. Midway, they come and they want to terminate the same case. This office, for example, gives, the same office of the ODPP, gives clearance for a case to be, to proceed to prior taking. Halfway along the line, they again decide, no, this should not proceed. In those other circumstances then, where this independence then should be subjected to some, will it be peer review or whatever, a higher level of scrutiny or evaluation or analysis.
Thank you, Honorable Chair, and thank you, Honorable Martin. Allow me to start by saying that the Constitution of Kenya is a product of a lot of research that was put in by the makers of the Constitution. And in their wisdom and upon doing research and benchmarking with other countries, there was need for these independent offices to have that tenure. You will notice actually the Office of the Auditor General and the Office of the Controller of Budget is 8 years, as opposed to actually the 6 years. And all the other independent commissions have been given the 6 years by the Constitution. So I would actually authoritatively state, yes, it's from research that these independent offices that were created under the Constitution of Kenya 2010 were actually given a longer tenure to ensure that they are able to perform their duties, first of all, without fear of being removed, and also, second of all, the Constitution also provided for clear mechanism of removal of commissioners or officers who do not perform their duties as they are supposed to do so. Even, for example, for the case of the ODPP, yes, it is an independent office established under Article 157 of the Constitution, and this office does not work alone. The makers of the Constitution and basically the architecture of our country was very wise in ensuring that we have an independent legislature, an independent executive, an independent judiciary. The ODPP takes their case to the judiciary. And so the biggest role here is first for the judiciary to ensure that such withdrawals and terminations are within the law, and to ensure that if the ODPP wants to withdraw a case or to cancel a case or to even reinstate a case, it is done within the law. In as much as these offices are independent, they are interdependent, and they do not operate in a vacuum. Somehow there is always an institution that is overseeing even these independent commissions. For instance, those offices report to Parliament, for instance, in terms of what they are doing, and Parliament has an oversight role as the legislature. The judiciary has a role in those cases, and this makes these commissions actually be subject to the law. They are subject to the law and the Constitution. They are independent, but subject to the law and the constitution. The enforcers of the law and the constitution are the parliament and the judiciary. So I think it's, there is a balance there that can be struck. I believe, as you've said, there is need to have courage and to be able to treat all political actors and all organs equally. Whether sometimes I know as commissioners you might have to take decisions or make declarations that might not go well to certain people, but I think this office requires that courage. Finally, I will move to Honorable Maungu's question on the issue of digital space. Very quickly, I can see the time is over. I think as a youth sitting in the commission, I will take advantage and leverage on my age, first of all, to be, if appointed, to be the front of a youthful face of the commission and a center of engagement with the youth, so that the youth can see that we can engage with youth as one group who understand each other, understand our needs, and use social media to actually leverage on that through influencers, through, in as much as it might not look serious, but TikTok, short videos, you know, those educational clips, and those are the things that actually reach the young people. So that if we need to go to the youth, and the youth are on social media, so we will go to them as a commission generally, as a team, and also as myself, I will also ensure that we are able to go to those digital platforms. If we need to communicate about national cohesion and integration through a TikTok video, then we will communicate through a TikTok video. If we need to have a public gathering through X Space, then, or a live on Facebook or something, then we will do that engagement there. I believe the digital space is a very good space to actually engage the youth and ensure that we deliver cohesion and integration through it. Thank you, Honorable Chair. Thank you, Honorable Dick Maungu.
Thank you, Nominee. Please, you have any closing remarks?
Thank you. Thank you, Honorable Chair and Honorable members and members of the Secretariat. I must say that I am indeed extremely humbled and happy to appear before this committee. It's a great honor and privilege to appear before you this afternoon. And I thank you for the guidance that I have received and for the good interaction that that has taken place. And it is my hope that when you retire to write your report, you will consider me as for appointment in the position that I've been nominated. Chair, if you'll allow me, when I'm still here, allow me to also appreciate the nominating authority, His Excellency the President, for this nomination. Thank you.
Just on that note, two things. I want to congratulate you. Eventually, the chair is supposed to be impartial. Now that we have gone through your vetting, literally, and at the tail end. At your age, you have achieved quite a lot. As a young person, you appear quite knowledgeable. And I want to congratulate you. As a lady also, you have done well. The outgoing chair of the National Cohesion and Integration Commission raised a complaint to Parliament about the appearance of the Commission before one of the committees of Parliament. And he said there was a solicitation for inducement for the chair and the Commission to be given audience by that committee. I want you to go on record and reveal whether either the chair of this committee, the members of this committee, the secretariat of this committee, or any person purporting to be their proxy has reached you and asked you for inducement so that you could be granted appearance before this committee.
Thank you, Honorable Chair. I confirm that no one has approached me to that effect. Thank you, Honorable Chair.
Okay, thank you. That is the end of your appearance before this committee. The committee will retreat immediately. You are the last person, nominee, to appear before the committee. The committee is retreating immediately for report writing. The report of the committee will be tabled before the House on Wednesday, and thereafter the decision of the House will be communicated. Thank you, and we wish you well.
Thank you, Honorable Chair and members.
Please confirm that all your original documents have been returned to you.
Very well, Chair.
Members, 1 minute, 2 minutes kidogo for in-house. On you know, even our venue for report writing has been kept under the wraps, so that this aspect of inducement, solicitude, is not part of the process that we are going through. So kindly, a few minutes. For the state, we want